We're just a couple weeks away from the United States versus Rahimi oral argument in the Supreme Court. I thought we would talk just for a few minutes today about how Matthew Wright, on behalf of Mr. Rahimi, may be preparing to win this huge argument involving our right to keep and bear arms. Stay tuned. We're going to break it down in geeky detail in just a minute. Hey folks, I'm Mark Smith, host of the 4 Box of Dine, a proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and author of Disarmed, What the Ukraine War Teaches Americans About the Right to Bear Arms. Obviously a book that the Israelis should have learned and read before the unfortunate Hamas attack. Having unarmed citizens is not ever a good plan, but we'll talk about that more down the road. All right, folks, so we have the Rahimi oral argument coming up in early November. We are going to cover that. We'll probably cover that live by live tweeting. And I thought I would just talk for just a few minutes about the sorts of things that an attorney preparing to argue a major court case, such as it before the U.S. Supreme Court, might go through, some of the processes. And then I would talk about like what I bring to the podium when I do major arguments, because it might be helpful to some of you out there as to how I do it. Maybe you can do something similar. Totally up to you. But I want to give you the sorts of things that I think that Attorney Matthew Wright, the federal public defender, down there in Texas, who will be doing the argument for Mr. Rahimi in the U.S. Supreme Court, and I'm sure he's going to do an excellent job, the sort of preparation and work that he may be undergoing right now. To begin with, as you know, I've shown you before in other videos the huge amount of documentation that's been submitted, not just for the pro-Rahimi attorneys, but also by those that support the government. So the first thing that Matthew Wright's likely going to be doing is he's going to read every single piece of paper and check out every single footnote and every single citation in all of those papers. That, of course, is in addition to the fact that he will have reviewed the lower court record, again, not just for all the law sites, but equally important for all the factual issues. He may get questions about the factual record. What was Mr. Rahimi's background? Has Mr. Rahimi ever been convicted of anything? If yes, what was it? And did it involve violence? What happened when the domestic violence restraining order was entered? Was there due process? Did he have a lawyer who was present? Was it face-to-face? Was it on the phone? And so on and so on. So again, Matthew Wright's going to need to know not just all the laws and all the historical analogs and all the different arguments made by both sides and their amici in the Rahimi case. He's also going to need to know intimately the factual record, the factual background of Mr. Rahimi and his case himself, Mr. Rahimi himself and his case background as well as to what happened in the lower courts. So that's what he's going to do first and foremost. And he's likely going to undertake a series of what are known as moot courts. Usually what happens when an attorney appears before a major court, including the U.S. Supreme Court, you have what are known as moot courts, where you bring in prominent lawyers and others that have familiarity with the subject matter, let's say, or the court you're appearing for before, and they will ask a series of questions. And you, as the lawyer who's going to argue before the Supreme Court, will stand in front of this moot court judges, and you will practice answering questions. And if you get things wrong, or you don't know things, or there's some that you can improve upon, there will be a colloquy going back and forth between the moot court judges and you to improve your technique and try to get it right, because there's a lot of questions that will be posed to you that you're not expecting. And the Supreme Court is notorious for this, that the justice likes to ask hypothetical questions and try to trip you up. And one thing is 100% going to happen. You heard it here first, 100% going to happen, is that Justice Elena Kagan, is 1,000% going to try to trip up Matthew Wright. She is the most dangerous Supreme Court justice when it comes to our right to keep and bear arms, because I believe she is the smartest liberal justice. I think she is more sophisticated and savvy and sharp and knowledgeable than both Justice Brown Jackson and Justice Sotomayor. And I think she's much more cagey in terms of trying to get outcomes that are much more favorable to the progressive point of view, given the fact that, of course, she was a longtime Harvard faculty member. I think she was even the dean of the Harvard Law School, a very, very smart individual, an extremely intelligent lawyer and judge. So Justice Elena Kagan, I think, is where the most difficult questions will come to Matthew Wright. I think those are the questions that he will have the most difficult time with. Only time will tell. We will see what will happen. So he will read everything that's been submitted, almost certainly. He will then have a series of moot courts, could be 2, could be 3, could be 4. It all really varies, and it's our personal preference and what's available to you. And then he's going to prepare, and this is where it gets very personalized. People do different things, but I'm going to tell you what I do, because I think what I do is essentially what all lawyers do in one form or another. I basically prepare 4 pieces of paper that I will bring to the podium with me. Now, sometimes these pieces of paper could be a couple pieces of paper, but basically there's 4 pieces of paper. And let me tell you what they are. And this is the sort of thing for those of you who maybe appear in front of school boards, or maybe you appear in front of congressional testimony or state testimony, whatever it is that you, or lawyers. These are the 4 pieces of paper I bring to the podium whenever I'm doing a major appellate argument. Okay? The first thing I bring to the table is a list of my arguments. Like, I have an outline of what I want to argue, that I want to convey, that's good for my client. So in this case, for example, involving Rahimi, I would stand up and I would say, first and foremost, my first argument is there is simply no historical analog that justifies 18 U.S.C. 922 G8. There was nothing close to a domestic violence restraining order at the time of the founding in 1791, and therefore it is a no-go. There is simply nothing there, and nothing that the government can argue from or relating to or implied from. It's simply no historical analog law. That would be the sort of thing that I would say is part of the chessboard. So that would be like a major argument that I would make on my first piece of paper, which again is really my arguments, my primary arguments that advance the balls for me. The second argument I would probably make would be something along the lines of there's simply no congressional authority under the U.S. Constitution, specifically the part of the Constitution that gives Congress its power or authority, specifically Article 1 of the United States Constitution. There is simply nothing in the enumerated powers set forth in Article 1 of the U.S. Constitution that would possibly give the Congress the authority to intervene and inject itself into local law enforcement matters like domestic relations. Specifically, I would say that 18 U.S.C. 922 G8, which deals, again, with domestic violence restraining orders, is a local police matter, and there's nothing in the Article 1 that simply gives them the authority as Congress to do anything about it. The closest thing they could possibly get is to claim that the broad understanding of the Interstate Commerce Clause somehow gives Congress the authority to enact this legislation, but it seems to me a big stretch to say that a domestic violence restraining order telling someone, that they can't be close to someone else, or can't be within 100 feet of somebody else, or can't be in the same room as somebody else, or any of these things, that somehow this it impacts interstate commerce. There's already Supreme Court precedent out there that says interstate commerce cannot be broadly construed in this context. So again, I think that might be kind of like the second gist. But again, the point is not the arguments. I'm not illustrating all the best arguments today in this video. I just want to say that would be the first piece of paper I would have, which are my best arguments that I want to advance on that one piece of paper, the points I want to get across. And I always ask myself, what is the single most important point I want to make to the court that I absolutely feel that I have to make? I write that down as number 1. What is the second most important thing I absolutely want to make to the judge, or in this case, the Supreme Court? That would be my number 2 point. I bring that up so if you ever, again, you're testifying in front of a PTA board, or you're talking in front of a committee, or whatever it is, a school board, whatever it is, the point is you want to say to yourself, what is the single most important point I want to make? And then what is the second most important point I want to make? And these are the things you want to put on the first piece of paper, which again are basically your arguments or my arguments. The second piece of paper I will bring up with me is what I consider to be my rebuttal points. This is a piece of paper that sets forth the most likely arguments I'm going to hear from, in this case of Rahimi, the anti-gunners. What will the government, the Department of Justice argue? I will have those arguments listed, and right below that, I will have my 1, 2, or 3 points as to why I think they're wrong. So, for example, in the Rahimi case, I would have on the second piece of paper, which is really my rebuttal points, my opposition points to what the government's going to say. One thing I would write down is the government's going to rely upon bans involving gun bans to the Tories at the time of the founding, meaning the individuals that refused to declare allegiance to the American patriot cause, they were disarmed because they were viewed as either Tories or someone sympathetic to the Tories. So I would write down on that second piece of paper, which are my rebuttal points, i.e. the arguments I most likely expect to hear from the anti-gunners in the case, and then my responses to each of those points. I would have written down that the Tories were disarmed they were viewed as dangerous, and therefore, if Mr. Rahimi is dangerous, I can disarm Mr. Rahimi. It's an historical analog. Now, I would, of course, have as a rebuttal to that no, that's not appropriate, because the Tories at the time were the individuals with whom we, the American patriots, were in a war against. And in this case, the domestic violent restraining orders has nothing whatsoever to do with a wartime activity. It has everything to do with you're in a civilian life, in peacetime, in America. You're not involving with any foreign enemies on our soil. So therefore, that now analog that the government might proffer, which is disarming the Tories in 1791, could justify disarming a domestic violence restraining order subject such as Mr. Rahimi. I would say that analog doesn't work, and here's why. And again, on my second piece of paper, my rebuttal points, I would again have the arguments I expect the other side to make and my responses there too, so I could quickly refer to it if for some reason I can't remember or I'm confused or something like that. If I don't remember, often, of course, I remember things off the top of my head. I don't need to look at any papers, but just in case, if you want a little bit of crush, you want to be safe, be able to take a quick look at it and jog your memory, because there's a whole lot to remember in these cases, and sometimes a little bit of a jog of the memory is perfectly fine given the voluminous nature of a case like the Rahimi case, because as you can see, the paper that is thousands upon thousands of pages of documents that have to be memorized and essentially and argued about. Now, the third thing I would have are my questions or answers to questions. I would anticipate, what is Justice Kagan going to ask me? What is Justice Brown-Jackson going to ask me? What is Justice Clarence Thomas going to ask me? I would have a list of what I expect to be the most likely questions that I'm going to get from the Supreme Court or from the court, and I would have those questions written down and my proposed or anticipated answers. Again, the first piece of paper is my arguments, my part of the chessboard, what I want to convey. The second piece of paper is my rebuttal points, meaning the most likely things I'm going to hear from the government side and my likely responses, the responses I want to make to it. And the third piece of paper is the most likely questions I'm going to get from the court itself. And I would write down those questions or notes about those questions, and I would put down what my answer will likely be. And I think there is quite a bit of question here. I think that Justice Kagan is going to ask a lot of hypothetical questions that Matthew Wright on behalf of Mr. Rahimi is going to have to be ready for. And that's the sort of thing I would have on my third piece of paper. And the last piece of paper is every single legal authority that I think possibly could come up, including all the case law, I would have written down on that fourth piece of paper with a little couple words there to jog my memory as to what that case is about and my particular position on it. So for example, I might write down, just to give you an example, I might write down Heller versus DC, and then I would indicate whether or not I view that as a good or a bad case for me. So I might write down Heller versus DC, the word good, which means I could just take a quick look at it and be like, okay, this is good for me, and a quick sentence as to why. Bruin, of course, now these are obvious ones, but the reason why I mentioned this is you literally will have hundreds upon hundreds of case citations at other sites and other laws, so it's hard to remember all these. Yes, you're probably going to remember all of them because you've spent literally months preparing for this argument, but the truth is it's not bad. So if the judge says, what do you think about the Cruikshank case? Or what do you think about the Mulberry case? Or what do you think about that case out of Kansas? Or what do you think about the English case out of Georgia? Whatever it is, if for some reason I don't know the answer off the top of my head, which I almost always will, nevertheless, things happen. You can forget, you can be tired, you can just blank. It happens in the real world, that happens. So to be ready for that possibility that you don't know the answer, you can have all your cases that you think may be asked about in alphabetical order that you can quickly look at. Oh, Cruikshank, good for me. Here's my view on it, good or bad. And that means that if you get hit with a question about a particular case by the Supreme Court or by a judge, whatever the court is, you are anticipating and you are ready to go. Again, this is how I do things. As to how Matthew Wright does it, I'm guessing he's going to do something very similar. It may not be identical to me, but again, I thought this was helpful to share it with you Second Amendment people out there. Maybe you do debates in your community, whatever it is. I generally think 4 pieces of paper is a good idea. The points you want to make. Number 2 is the rebuttal points you're likely going to hear from the enemy arguments that you want to be able to rebut. The third one is your answers to the tough questions you might get from the Supreme Court or from a court, or if you're doing public speaking from, let's say, an audience member, that would be your third piece of paper. And the fourth piece of paper, if you're dealing with something that's heavy legal authority, a lot of laws, a lot of historical analogs, then you want to have those in alphabetical order with a quick word, good, bad, or neutral, and then a quick explanation as to what the case is about and what you think about it. Again, just in case you blank, because there's a lot to remember, and people do blank. It's not a fault. It's just, again, the voluminous nature of these cases, the complicated nature of these cases. It's hard to remember everything. Even the best can sometimes need to have their memories jogged. It's not unusual and is not a bad sign. So anyway, I'm guessing that the attorney Matthew Wright is going through this process right now. We're all hoping and praying and cheering for him that he's going to do a great job. I'm sure he will when the time comes in a couple weeks before the U.S. Supreme Court in early November. And again, we here at the Four Boxes Diner will certainly be covering it. I know I'm already going to be doing a outside the courthouse discussion of this case for the Federalist Society in a telephone conference call the afternoon of that argument, after the argument. So I know I have a lot of media and other related things I have to do involving the Rahimi case. But of course, my high priority will be to make sure that I report to all of you out there in the Four Boxes Diner what just happened and what I think it may mean for the ultimate outcome in that important Second Amendment case. All right, folks, hope you learned a little bit something here today. Hope you found this interesting. And again, if you haven't subscribed to the Four Boxes Diner, please do so. Don't forget to follow me on X at Four Boxes Diner, and we will see you again soon here at the Four Boxes Diner.
Orders up. Table 2A.